thanks very much, Deborah. So hopefully you can see in the chat that Deborah has helpfully answered question 1 for us. So yeah, so we're back to this thing about the criminal liability equation, and we will repeat this frequently because this is part of the sort of fundamental key, really, to understanding criminal liability. So Deborah's absolutely right that the criminal liability equation is where we think about the actus reus plus the mens rea. If they're both present and there's an absence of defence, then there will be criminal liability. Just a follow-up question for Group 1. What's the exception to this general equation, thinking in particular about mens rea? Perhaps someone from Group 1 would like to help us with that. Yeah, exactly right. Brilliant. So thank you very much, Aisha and Deborah. So yeah, so you remember from last week, hopefully, that exactly as Aisha and Deborah say, that the exception to the general equation is if we're talking about a strict liability offence. So there we would be saying that it's the actus reus plus strict liability is equal to criminal liability. Okay, so let's move very swiftly on. Thank you very much, Group 1. So let's move on to question 2, and we're asked here to explain what is the meaning of the term actus reus. So if I can come to Group 2, which was Chloe, Gaia, Kaya and Sophie, if someone from that group could help us with question 2, please. Brilliant, thank you very much, Chloe. So Chloe is suggesting that it's the guilty act, and Sophie, you're suggesting that it's the action that caused the crime. Yeah, so I think you're both right there, and this sort of leads us on to the next question, because what you'll remember from last week is that we were talking about the actus reus in a little bit more detail, and you'll probably remember that we said that it's all the external elements of the crime, and Sophie, you're quite right to pick up on causation, because that's certainly one of those. So well done to both of you, Chloe and Sophie, thank you. So let's move on to question 3 now, which Sophie has helped you with, really. So I'm going to come to Group 3 now, which was Chelsea, Evie, Folashade and Jemina. So could someone from Group 3 help us with this? Right, brilliant. Folashade, I think you're ahead of me. You've been typing in advance. Right, okay, so Folashade is suggesting that the 4 C's are conduct, circumstances, concurrence and causation. So let's see. So just to pick up on something there, Folashade, before we move on to have a look at the substance of that question, just to pick up this issue of criminal intent, because if you remember, intent is actually one of the ways in which the mens rea, i.e. the mental element, can be established. So just to clear up any confusion about that. And in terms of the 4 C's, you're absolutely on the right track. We've got conduct, that's absolutely right, circumstances, absolutely, causation, absolutely. And then the other thing, I can understand why you're saying concurrence, because we were talking about the principle of coincidence last week, weren't we? But actually, when we're thinking about this, we're thinking about consequences. That's right, Chelsea, exactly. So thank you very much for that. So a good bit of teamwork there, that's what I like to see. So thank you to both of you. And then let's move on then to question 4 and Group 4, which is Brendan, Caitlin, Isabella and Sana. So Group 4, can you help us with this next question? So when will an omission to act amount to criminal liability? So Group 4, can you help us with that? And do feel free to put a microphone on if you're feeling brave. Oh, Brendan, marvellous. So Brendan, you're saying where there's been a duty of care and that the duty was breached and there's a I think you might be saying causal rather than casual connection between the breach of duty and the harm suffered. Right, okay. So Yeah, that's all right. I know it's difficult to get all the typing right when you're desperate to say something. Okay, so Brendan, thank you very much for that. Can anyone else in group 4 develop this a bit more? Or to come in here to help Brendan? So Caitlin, Isabella and Sana, can any of you help Brendan here? No? Okay. Now, Brendan, your answer to this particular question is not right, but I'm really pleased that you have given us this incorrect answer because it helps to illustrate a really important point. So I am very grateful for that. So what Brendan is saying is that an omission to act, an omission can amount to criminal liability where there has been a duty of care. Now, a duty to act is not the same as duty of care. So I think what's happened here, Brendan, which is very common and not difficult to see why at all, is that there's a bit of confusion between this concept of duty of care that you'll be studying in tort and the very different notion of a duty to act in criminal law. So it's really important that we do distinguish between duty of care in tort, and park that over there, and duty to act for the purposes of criminal law. Okay. So does anyone know what the particular circumstances are where an omission could amount to criminal liability? So what are the circumstances where there would be this duty to act in criminal law? And if anyone at all would like to answer that, that would be marvellous. Thank you. Marvellous. Yeah, that's great, Aisha. Thank you very much. Yeah, so you'll all know that the general rule in criminal law is that a failure to act, an omission, does not lead to criminal liability. But Aisha is absolutely right. There are these exceptions in these particular circumstances. So, yeah, so where there's contractual duties, where there's a special relationship, and by that we mean a relationship of dependence. So like a parent and a child, or patient and doctor, and so on. And then there is this issue about voluntary assumption for the responsibility for another. So yeah, so where exactly as you've set it out here, Aisha, where the defendant has volunteered to look after the victim. So okay, so that's excellent. And Fabio, you've come in here with where a person has an obvious duty to public safety arising from a dangerous situation. So yeah, so I think that sort of overlaps a bit with the official duty, doesn't it? The obvious duty. So perhaps if you've got an off-duty police officer or something like that. So okay, excellent. So let's move on from this business of omissions and move on to the last question. So you're asked here to set out what steps need to be taken to prove causation. And hopefully you will remember a little bit about this from last week when we started to explore causation in the context of criminal law. So I'm going to come back to group 1. So Aisha, Anisha, Deborah and Kaylee, can you help us with this one? Okay, brilliant. Thank you, Deborah. Yeah, so factual and legal causation, they are both required. So what do we mean by factual causation? Open that up to everybody. remember factual causation from last week? Okay, so yeah, Deborah, you've got the classic expression of this there. So we're talking about the but-for test. Thanks, Aisha, and Chelsea too. So yeah, we're talking about the but-for test when we're talking about factual causation. So but for the defendant's conduct, the particular result happened. So that's absolutely the right thing there. Does anyone remember the case that we would often expect to see referred to as the authority for this test in criminal law? Exactly right, R and Y, that's it, for factual causation. But how very helpfully, Chelsea, you have helped us with legal causation. So Chelsea, you're right that we would be probably thinking about Paget there, which we're going to come on to look at in quite a bit more detail later on in the seminar. And you've said above, Chelsea, that the defendant must have been a significant cause of what happened. So that's right. And the sort of classic formulation of that is to say that the defendant must have been a substantive and operating cause. And then Fabio, you've come in here, the defendant must be the factual cause of the offence. So yeah, so it's saying that they must be both the factual and legal cause of what happened. So, but for the defendant's act, the result would not have occurred, and also that the defendant was a substantive and operating cause of what occurred. And you might remember that in order to break that chain of legal causation, we would need to be thinking about intervening acts of various sorts. Okay, so I think we're fairly clear on the two tests for causation. And as I say, we'll come on to look at legal causation and the case of Paget in a bit more detail later on. Okay, so hopefully all those questions have got our criminal law brains warmed up. Does anyone have any questions at this stage, pardon me, about any of that? You feel like you've got the basics there? Paget, yeah, what is the year of Paget? I don't remember. No, 1983. Okay. Yeah, so that's the case that that we would often imagine that we'd want to see as an authority for discussion of legal causation. And R and Y is the authority for factual causation. That's right, Fabio. Yeah. So if you remember, R and Y is the case about the guy who tried to poison his mum, and factual causation was not present there because although the mother did die, it was not as a result of the poison. She had a heart condition, and that's what caused her death. So we wouldn't be able to say that but for Mr. White's actions, she wouldn't have died, because she would have done because of this heart condition. So, okay, good. Any other questions or comments at this stage? Okay. Right, well, what I would suggest we do then, it's just about after past. Let's have a go through these multiple choice questions together. And what I would really like a lot is if I could encourage you to answer these by putting your mics on. So we're in week 3 together now, and hopefully starting to feel like we're getting to know each other a little bit. So I would very much encourage you to pop your mic on and answer some of these. So we'll just go through these together. So does everyone have access to the MCQs, or can I just take a show of hands? Would you like me to put those up on the screen? Yeah, okay. I will do. So just bear with me. I'm just going to put that up now. hopefully everyone can see that. Okay, so question 1. And also what I would also really like is, as well as giving us the answer, so A, B, C or D, if you can also explain why you're suggesting that's the correct answer, that would be very good indeed. So let's start off with this one then. Question 1. Which of these statements is correct from A to D? The study of the criminal law is a study of what? So if I can encourage someone to put their mic on and have a go at this one. I see we're still feeling very shy. Oh, hello, Aisha. How are you? It's very nice to hear you.
I think it's which is
okay, go ahead. Yeah.
Because it says if I start coming around,
Yeah, exactly right. Yeah. So absolutely, A is the correct answer there, and that is the most complete answer and the most accurate answer. So that's why we're banging on at you all about the criminal liability equation, because that's what all this is about. So thank you very much, Aisha. Let's move on to question 2 then. I shall scroll down. So which of the following, A, B, C or D, is not an element of criminal liability? So who'd like to come in on that one? Be brave. So let's think about this. You all know about the criminal liability equation. So given that I know that you do know that, I also know that you will know the answer to this question, because there is something on this list that we don't talk about in terms of the criminal liability equation. So which one is that? If you really can't feel brave enough to put your right, okay. I see we have some things in the chat. Excellent. Yeah, okay. Yeah, so thank you very much, Gaia, Isabella, Sophie, Fabio and Chelsea, and I think Kaya, yes, C, that's right. So yeah, you're all absolutely right. It's motive, so very straightforward. I knew you knew the answer to that. So let's see about question 3 then. Most prosecutions are brought by whom? And again, I know you know this because we talked about this, I think, in week 1. And you were all very clear. So again, so you're saying C and D, Chelsea, and Fabio, you're saying the Crown. So yeah, the Crown prosecution. Yeah, okay, good. So you're absolutely right. The most prosecutions are brought by the CPS, the Crown Prosecution Service. But Chelsea, don't be too hasty there, because of course you're right that local authorities can be prosecuting authorities for certain kinds of offences. Although it is still true to say that the CPS are the main prosecuting authority. So, but it's not that local authorities don't; they do. And other places that you might have heard of that will bring prosecutions: the Health and Safety Executive, the Office for Nuclear Regulation, the Environment Agency. All of those organisations are prosecuting authorities for very particular types of offences. But yeah, CPS is definitely the main one. Okay, so let's move along here. Who bears the burden of proof in criminal proceedings? just take a look at those first two options, and I'm going to flip to the next page so you can see C and D. Okay, so just bear those in mind. Okay, so you can see, those are your options here for question 4. Who bears the burden of proof in criminal proceedings? A, the judge, B, the jury, C, the prosecution, or D, the defendant? Who'd like to have a go at that? Okay, so we've got a couple of different answers here. So who bears the burden of proof in criminal proceedings? So I've got lots of people saying C, the prosecution. And then a couple of you have said D, I think, here. Now, the correct answer is C, is the prosecution. That is who the burden sits with. The defendant very rarely has to prove, that they're not guilty. It's for the prosecution to prove that they are. Sometimes the burden can shift in what we call reverse burden cases, or for particular elements of an offence, but generally speaking, the burden sits with the prosecution. Okay, good. Let's move on to question 5. So, thinking back to the 4 C's of the actus reus, which of the following is false? The actus reus of an offence consists of what? Which of those is incorrect? And again, I know you know this because we were talking about the 4 C's of the actus reus just a few minutes ago. Okay, so absolutely, you're quite right. D is the incorrect answer there because exactly right, Fabio. Yeah, thank you. So, yeah, the defendant's state of mind is nothing to do with the actus reus, but it's all about the mens rea, as you say, Fabio. So, thank you very much. So, let's move along. Question 6. So, you've covered in the next lecture now this idea of result crimes. So, which of the following from this list, A, B, C, or D, is a result crime? Which of those requires a particular result or a particular consequence to occur? Yeah, exactly right, Gaia. Yeah, and you're on it. Yeah, thanks, Chelsea. Thank you, Sophie. Okay, Fabio, you're asking why. Could I please invite you to pop your mic on and explain your question in a bit more detail? What's the why related to?
No, hi. I was just wondering, why is murder? Why is murder the following is a result of crime? Why is it murder? What elements do they have to be for it to be? Well, I don't know how to formulate this question, but what elements leads to murder? Has to be for murder. I don't know if I'm asking it right, but just wanted to know why.
That's absolutely fine. Thank you for your question, Fabio. So if we think about this then, so we're saying we've got the correct answer here, murder is a result crime. Can anyone who answered this, so Gaia, Chelsea or Sophie, can you help answer Fabio's question? Why is murder a result crime? Yeah, exactly right, Chelsea, thank you. So yeah, there you go, Fabio. Chelsea is absolutely right. The reason why murder is a result crime is because there has to be the death of another person. So if somebody has died, then murder might be a relevant offence. Okay. So hopefully you can see that with the others, there's no particular consequence or result that is required. Yeah? Okay. Marvellous. This is what I like to see, you learning from each other, so that is brilliant. Right. Excellent. Thank you, Fabio. Let's move on to question 7 then. So, which of the following is a conduct-only crime? Right, Sophie, yeah, straight on it. So why, right, okay, so let's have it's interesting. So Sophie, you're suggesting theft, which is indeed the correct answer. So you're there with that as well, Shade and Chelsea. But I'm interested to come to you, Aisha, about why you say manslaughter. Do you want to tell us a bit more about that?
I think I thought it was manslaughter because you know, you can get murder reduced down to manslaughter when you don't have the murder. So I thought maybe, or like when you know, I don't know. I think I thought it was manslaughter because it's like an accident, like maybe you want to cause it to death. I don't know.
Okay. No, well, let's just think about this for a minute, because you're right that murder can be reduced down to manslaughter if there is, a partial defence. But if you think about what happens in a manslaughter case, if you remember, or we won't have covered this yet actually in particular, but someone still has to die, so there still has to be that particular result for manslaughter to be in play. Okay.
Yeah.
So that's
RBY. I thought of RBY because he got it reduced down to manslaughter. So I just thought it was his conduct that got him, because he didn't actually cause the murder, but he did carry out some conduct. I don't know. I just
That's all right, don't worry. No, this is really good. This is why it's really useful to kind of talk these things through, because then hopefully I can make sure that by the time we finish this, I've cleared up any sort of confusions or anything. So this is excellent. So what did we say? Yeah. So let's think about the other three then. So we know that the right answer is theft, that's a conduct-only crime. So what if we're thinking about results? Because the other three are result crimes. What are the results we would be expecting to see for an ABH, a murder and a manslaughter? We've already answered B and C, really. Anyone want to have a go at A? What would be the particular result there? Chloe, okay. Yes, so Chloe, you're absolutely right. There has to be some injury, and Chelsea, yes, that injury, harm to another person, yeah. But the particular thing about actual bodily harm is that it has to be injury of a certain level. So it has to be sufficiently serious to amount to an actual bodily harm. So more serious than a common assault, less serious than a grievous bodily harm. So something of the right level of seriousness has to occur as a result of the defendant's conduct. Okay. Just to come back to you for a moment, Aisha, I think I can see where your confusion is about the White case, because you're right, he was convicted of manslaughter, but that was because of problem of causation, not because it was a conduct-only crime. So do you remember we were talking a bit earlier about the fact that the but-for test couldn't be made out in White's case because we couldn't say but for him poisoning his mother she wouldn't have died, because she would have done because of her heart condition. So that was the problem there. That's why it was reduced down. So yeah, hopefully that makes sense now. So good. All right. Right. Well, let's move along then, shall we, to question 8. So, which of the following crimes cannot be committed by omission? So the choices are A, robbery, and I'll just move along. B, murder. C, manslaughter, or D, criminal damage. So which of those cannot be committed by an omission? So you remember an omission is a failure to act. Okay, so the correct answer here is actually robbery. That's right, Gaia, yes. So that's what we would be looking for there. So question 8, the correct answer there is robbery. Okay. let's move along then to question 9. So, thinking about causation, and again, I know you're all very familiar with this now. What sort of crimes are we thinking about when we know that we have to prove causation? Okay, good. Yeah, result crimes. Exactly right. Yeah. So A is the correct answer there. Yeah. Very good. Okay, so that's absolutely right. Let's move on to question 10. So last but not least, which of the following statements is correct? So A, D is liable only if the prosecution can prove D's acts were the sole cause of the result. B, D may be liable if the prosecution can prove D's acts were a significant cause of the result. C, causation is a simple question of cause and effect. Or D is liable even if the chain of causation is broken. So which of those statements is correct? Okay, Aisha, you're saying B, yeah. Chelsea, B, yeah. Okay, good, yeah. So I think you're definitely on the right track here. So B is absolutely the correct answer. And why is that? What's the case we might be thinking about there? And perhaps another way we might phrase significant cause. Right, Chelsea and Aisha. Okay, so Aisha, you're correct. This is where we would be thinking about Paget. And the reason for that is because this is obviously a statement about legal causation. So this is where we're talking about being the substantive and operating cause, or here obviously we're describing it as the significant cause. So it's a legal causation point, so we would be thinking probably about Paget. Now, Isabella, you're referring to a case where the girl jumped out of a moving car. Yeah, I know the case you're talking about, and at this point in time, I'm struggling to remember the name of it. Can anyone help? Anyone remember the name of that case where the girl jumps out the moving car? I think it might be Roberts. Yeah, it's the one where she thought she was going to be sexually assaulted, I think, isn't it? So she jumps out. I shall look that up. Perhaps someone else might like to look it up as well. That's right, Isabella. Yeah. So yeah, we're thinking about the same one. Okay. So we come to the end there of the MCQs. Well done, everyone, and thank you for engaging with that. So we are now going to come on to the third exercise. I'm just wondering whether perhaps we ought to have a quick break now before we move on to look at these problem scenarios. Perhaps we'll do that. So my laptop clock now is 2:52. So can we come back in, say, 5 minutes' time? So just before 3 o'clock. So my clock's just changed, actually.